Sydney family to lose $1.35 million dream home over hidden mortgages. So this story was covered on A Current Affair, and let's unpack this together. The purchasers bought a property in Silverdale for $1.35 million. And what happened was just before settlement, the brakes were put on and a caveat was lodged. And this prevented the purchasers from completing the settlement. And what this is related to is some debts that the vendor had. So because the vendor might have had some secured debts, it could be private finance or it could be debts related to a business. It doesn't particularly say. This means that without those caveats being withdrawn, the purchase could not go through. So in this situation, the purchasers have the option to serve a notice to complete, which would give the vendor 14 days to complete the transaction. And in this case, after 14 days, the purchasers could cancel or terminate the contract and get their 10% deposit back, but they wouldn't get any damages or any real refund of their time or opportunity costs or anything like that. So if you want to complete the purchase, you don't really want to serve that notice to complete and terminate the contract. You want to complete the contract. But without the caveats being removed by the people that have lodged those caveats, this isn't possible. So you're stuck at a standstill. And the question would be, how could you avoid this? Look, it's sometimes unclear, or it could really be unclear when you are reviewing a contract for sale if there's no caveats on the title search when the contract was prepared and reviewed and they're lodged after you sign the contract. You don't have a way of really knowing whether the vendor has these type of debts. So it is really a stark reminder that, in the end of the day, nothing is 100% until settlement occurs. What can they do other than this? They could sit tight, wait and see if the vendor could remove those caveats or negotiate with the caveators to get those removed and then potentially settle. If not, and there's some other debts and the mortgagee wants to repossess the home, this could mean that it is a mortgagee in possession and they may not honor the contract that the purchasers entered into. So look, this is something that you've got to really look out for potentially, and is quite shocking, concerning, and worrying for a purchaser under these circumstances. But it's a case by case basis, right? Ultimately, what you've got to look at is, like I said, you can't actually mitigate every risk. I don't think this is a very common scenario for people to be dealing with. I don't see this all the time. It's common to see, or somewhat common to see, caveats on title when you're buying a property, and you can make a judgment call on whether that is something that you're willing to onboard in terms of risk. And your solicitor or conveyancer should advise you if there is caveats registered on title when you're buying the property. If you've liked this type of content, please comment and like it and share it and let me know so that I can bring out more content like this. Thank you for watching, and I look forward to chatting with you again soon.